Welcome back to What I Missed TV. Attorneys Brian Steele and Max Schardt schooled Judge Paige Whitaker with the law when she was trying to deny them the right to cross-examine star witness Kenneth Copeland regarding the ex parte meeting. Now, witness Kenneth Copeland did an interview with DJU TV, and he spoke out about what happened to him when he pled the Fifth, and Brian Steele brought it up in court. Now let's take a look.
Morning. All right, Mr. Schardt, I got your motion limine. Is that something we don't anticipate that coming in today, right? You're just getting a jump on things, which I applaud.
Well, thank you. It may come up in my cross of Mr. Copeland.
Okay. And it hasn't already been admitted, right?
No, it hasn't.
Okay. And we discussed it a little bit before.
Yes, Your Honor. Your Honor, I tried to argue 403 about it, and Your Honor did not agree with me. And so I know it's coming in.
Right.
The issue is
that date.
We're assuming that date, and that date, it says that date on the printout, but
which is not anything like what it looked in the original, right? That looks like it's just added on there. Let's find out.
I'd be speculating.
Okay. Ms. Hilton.
When I looked at Mr. Schartt's motion, I might have missed it. I didn't see the January.
So there's the picture or the post is attached, and there's this kind of weird little thing floating over the post on the right border. Yes.
I could clarify. My issue is everyone's been telling me that was posted on January 10th, 2015. The state has been operating on the assumption that is a fact, and I don't.
It hasn't been established.
Yeah, I don't understand how this has been established as a fact.
We'll hear from Ms. Hilton. Do you want to just look at my copy? Okay.
We're double checking, but my understanding is Quindarius Zachary, I believe in his interview, says that he took this picture and that the picture was taken prior to January 10th. It may have been posted on January 10th.
That's not the issue, is when the picture was taken. The post has this date hovering on it.
Correct.
That's his issue.
Right. So as far as the January 10th, I think there's an explanation as to why the January 10th is there. So if it's to come out, there's an explanation for the January 10th.
Okay. So a couple of different things. Okay. Did the post ever look like this rendition or do you have what you intend to submit? Let's start there.
Your Honor, at this time, we didn't intend to submit this picture into evidence. So.
Okay. And what you intend to submit will have this little January 10th box hovering?
Your Honor, we don't even know if we're planning on introducing this picture. So that's why I think he's doing it precautionary, but this is not any.
Okay.
Hold on.
Well, then I guess, Mr. Schardt, you can use the post without the January 10th hovering over it, if you want to use it.
My cards face up on the table. It is. I may want to introduce it, but not if it's going to be otherwise inadmissible. And so.
Okay.
I just don't. We've been proceeding like it's a fact that this is taken on January 10th. How do we know that?
So with or without the.
Or I'm sorry, not taken, the posted.
What's your basis for asserting that it is posted on January 10th?
I don't know when we've asserted that in trial. This is a picture that we served. It has the January 10th date on it. I don't believe I have ever communicated that we believe or disbelieve that this was taken on January 10th. I think our understanding, and I'm just confirming, is that we believe the picture itself was taken prior to the 10th, but it might have been posted.
I understand.
But whether or not it was on January 10th or how this date arises.
Okay, well, number one, you need to figure out why that January 10th is on there. And number two, if it wasn't posted on January 10th, what's the relevance?
We agree, and that's something that if we decided to enter, we would have determined that. I don't know if this is a picture that we were going to enter, so it's the voluminous amount of information. I don't know if this is a picture.
Right, because y'all haven't exactly organized your case yet. All right, Mr. Schardt, they don't know whether they're going to use it or not. And they don't seem to, it would not at this point be admissible, but I can't tell you if it might be admissible at some other point when they get their case organized.
And you're right, it's not about the case not being organized, it's about whether or not we were using this particular piece of evidence. Like there we have a multiple of social media.
Right, well, you don't know whether you're using it, and you don't know whether it is relevant. So, because you don't know when it was posted or why you think January 10th is on there. So we just don't know. So,
Your Honor, in the previous motion, the state asserted it was posted a couple hours after the killing of Donovan Thomas. So if that is not the case and they cannot assert that, I would ask that this post be deemed inadmissible because it has no relevance and it.
I'm not going to deem it inadmissible because maybe at some point during their case, they'll come up with why they think that. Do you know what motion it was in? Maybe that'll help Ms. Hilton get to the source of.
It was argued in front of you.
Yeah, I remember that.
Okay. I'm trying to remember what brought it up.
Maybe it was Ms. Love. I don't know. Maybe you need to speak with co-counsel.
Yes, I'm trying to. I believe we were going through the proposed exhibits upcoming, and I brought that up. But
yeah, you brought it up. I don't think we have gone through much social media yet. So I think you brought it up, and they said, but I don't remember who the they was over there at the time.
I don't believe it was me, Your Honor.
Okay, well, maybe check with Miss Love. But I think it's going to be several hours, if even today, before there's any cross-examination anyway. So maybe we'll know the answer by the time we get to the cross-examination portion of the case. Also, that reminds me that with regard to cross-examination, I know, Mr. Steele, you had at one point suggested an interest in cross-examining Mr. Copeland as to everything that went on during the ex parte. And some of that is no longer relevant. So anything, I mean, if you want to cross about things that the state said to him or that he said to the state, that's fine. But we have, I think, both circumvented and the whole coercion issue, and he has now been properly and correctly advised by this court and had the advice and counsel of 3 different attorneys that I know of. So that should no longer be an issue. And so that should no longer be relevant. So I would not permit examination or testimony about that. All right.
Well, of course it's okay because you are the honorable court. But I will make an attorney proffer.
Okay.
Because if you'll accept it, otherwise I could do it with Mr. Copeland. But I respectfully disagree.
Okay.
Mr. Copeland on the 7th of June 2024 stated, and in my way I understand the law, he doesn't have a Fifth Amendment, but he refused to testify. And he
Correct.
And he used the Fifth Amendment as whatever, his statement. He made it clear to me as a reader of the June 10th, 2024 ex parte meeting that he was not going to testify. he said in court, outside the presence of the jury, that he was pressured. Please check the record with Ms. Winfrey. If he didn't use that word, he used a similar word.
Mhm.
He would never have testified except for that ex parte meeting where Judge Glanville pressured him, as well as Ms. Hilton. So I believe that it does go to his state of mind while he started to testify. Your Honorable Court, correctly, in my understanding of the law, told him what is his options and how long he's looking in custody, and told him, I believe, the decision's his. The legal decision, though, will trigger you to have to exercise your discretion and hold him in contempt. So I believe that the jury gets to determine that information. In addition to that, Judge Glanville was with us since January 4th of 2023. This jury is all selected from the very first panel. To me, he was biased in front of the jury. I understand that what you said, that, no statement, I appreciate what you said. No statement made by the former court disparaging of lawyers should be considered, or whatever the words were. But there's also going to be a jury instruction that nothing that the court says is intimated an opinion. And I disagree in this case with that instruction. I'm going to object to that instruction. And I need the jurors to understand that Judge Glanville, I will make it clear. I will make it clear. I will make it clear. I am excluding this honorable court. But Judge Glanville pressured him. And I will argue to the jury that Judge Glanville was biased. And that is admissible because it all happened in front of the jury. And from just Judge Glanville's demeanor, and I'm not here to hurt Judge Glanville. In fact, I like Judge Glanville, but I don't know what happened in this case, but I like him before this case. But the way he conducted himself to people in this courtroom, I've never really seen a judge do. So I want to ask Mr. Copeland, it is very important to me to explain that he was taken against his desire into Judge Glanville's chambers, that he was with Judge Glanville, Miss Hilton, his lawyer. I'll make it all perfect. If I don't, you could admonish me and the state can correct me, but I'm not here to snowball anybody. But to say that I can exclude statements of Judge Glanville and, most importantly, the conscious or subconsciousness of this witness, because I believe, and I've not spoken with him, Your Honor. I've not spoken with his lawyer about it, but I believe that Mr. Copeland will truthfully say that he believed that Judge Glanville and the state of Georgia are one. And that comes out when Judge Glanville specifically says, and I don't remember the transcript page right now, but it's something to the effect of, we need your testimony. There's no we. Nobody needs anybody's testimony. If he didn't want to testify, I've had witnesses tell me, I'm not testifying. We subpoena them and come to court. They're held in contempt. There's nothing that the judge can do because the judge can't give immunity, so they can't compel the person to do it. So the person invokes their Fifth Amendment and they just leave. That is unfortunate, but that's a reality. There is no we. So with all that being said, I'm making an attorney proffer that if you prevent me from doing that, and Judge Glanville prevented me already, I'm just telling you, he prevented me from cross-examining Agent Racy. He's an FBI agent on misstatements made by the prosecution, knowing the prosecution, it was Ms. Hilton, knew that a gentleman who's the same last name as a court reporter entered an invalid, coerced guilty plea. Judge Glanville stopped me again from getting into the truth of that matter. It's never been corrected. The point I'm trying to make to you is that all came out in front of the jury. So yes, I am going to intend I will follow your rule, obviously, but I intend to cross-examine Mr. Copeland, not only what was said by Ms. Hilton, but what was said by Judge Glanville. I will be respectful. I'm not here to, throw some odd names about Judge Glanville. I will just be very specific. And then if he doesn't answer my questions, I'm stuck with his answer of, I don't recall, or whatever has been going on in this courtroom. But I don't believe that you should limit the cross-examination. I didn't do that. You know, all that to me, that was very hurtful to me. And I don't mean hurtful. I mean, you know, it was offensive to our law. That's how I took that. And I know what you said about it. I know what Judge Krause said about it. I look at it totally differently. I've never had a judge do that. I've done a lot of appeals. I know you've done a lot. I've never read a judge doing that. I've never seen a prosecutor do that. So I think that the jurors are entitled to know, and I think Mr. Williams, because he's the one who, God forbid, gets sentenced if I lose, I think they are entitled to know what caused Mr. Copeland from the 7th to be locked up. The jurors saw that. They saw that. He was testifying. He answered maybe 3 questions, maybe 5. He said, I'm not testifying. He invoked his 5th. The jurors were sent out and he was gone. Jurors come out and they're dismissed. He's just not there. We're on a long delay. I think that it is not irrelevant to this matter. I think it is more than relevant. I think it's probative. And this is the actual treatment by the former court and the current district attorneys of this case.
Okay, I understand your argument, and I am not making my ruling in any sort of an effort to protect Judge Glanville. I do not believe it is relevant to the issues for this jury to determine. With regard to whether Mr. Copeland's testimony between the 7th and the 10th was, I'm sorry, between the 10th and the 12th, was impacted by the ex parte on the 10th. I asked everybody, do we want to do the entirety of Mr. Copeland's testimony over? And everybody said, no, we want what got testified to between the 7th and the 12th at 3 p.m. So y'all had the opportunity to have it all done over, and you chose not to do that. You can ask him about the immunity and whether he'd be testifying without being ordered to. That's fine. But beyond that, the ins and outs of what happened in the ex parte with regard to whether there was a biased judge or not are, in this court's legal opinion, not relevant to these issues. And honestly, even the "we need your testimony," Judge Glanville had made a determination that Mr. Copeland's testimony and compelling that testimony by an immunity grant was in the public's interest. And so the "we" there is Judge Glanville, or can very easily be understood to be Judge Glanville saying "we, the public," and not "we, me, and the state." So I appreciate your proffer, but my ruling stands.
Can I just add to that then?
Sure.
So it's in the eyes, the mind, and the ears of Mr. Copeland, not a reader who can say, well, that's the public. In addition, Judge Glanville said to Mr. Copeland, on cross-examination, you are going to get tremendous cross-examination. And they know you better than we do. So they know what you did. The they, I would ask Mr. Copeland, is referring to Mr. Williams, Mr. Ryan, Mr. Nichols, Mr. Stillwell, Mr. Kendrick, and Mr. Huey. And that presumes guilt, because Mr. Williams does not know the reality that Mr. Copeland has done all this other things, like pull a gun on Mr. Watts that he admitted today, shot into a barber shop that he admitted to on the stand. These are outrageous conducts. For Judge Glanville to make that statement, yes, the jurors should hear about it and the effect of Mr. Copeland. And you are respectfully taking away the opportunity that we are all given. Judge Glanville did this to a witness that's currently testifying. And if you don't realize this, because this is, I think, your first witness. This is a big witness. He has been spoken about the entire case. I've opened on him. I said that Mr. Copeland killed Donovan Thomas. To remove this, I believe, is going to be under the analysis of has to be harmless beyond a reasonable doubt because it's a constitutional violation. So I'd ask you to listen to the remainder of the June 10th, 2015 statement, because he's going to talk about, he already has, and if you can't understand it, the transcript seems to be, in my opinion, fairly accurate, where he talks about Mr. Williams. And if he didn't testify, none of this comes in. I think the jury gets to know that and why he testified. And it was because Judge Glanville held hands with Miss Unlove and Miss Hilton, and they coerced this man to testify, pressured this man to testify, whatever his words would be. So I ask you to just, I understand your ruling. I'm going to follow your ruling. I hope I made a good attorney proffer on cross, but those are the topics I would go in. I would not go into, Neil also was, by the way, I have, based upon information, belief, he wasn't fed and did not drink from Friday when he was held in custody until Monday when he's in that star chamber. So I think that goes to his frame of mind as well. So, and when I say he, I'm talking about Mr. Copeland. And he was put into a jail in DeKalb County where the system was down, at least that's what he was told. He couldn't contact a family member. So I think that all that adding up to make his determination that, yes, I think that it's a corrupt system and the judge and the DA were going to hold me for not only this trial, but who knows how long 26 people can dispose of it.
Up or whatever, because this is what they're going to do. They're going to harass you.
Yeah, man, for sure that. And, you know, with the trial just being broadcasted, right? It's down to like TV, the way they got it on YouTube. You know what I'm saying?
Man, I'm going to talk about the trial. When I played the fifth man, you know what them people did to me, man? They took me to jail. So when I got to Fulton County, they put me in general population. I laughed because I already expect this. So I say, dang, they going to put me with everybody? I said, I'm not to fight, though. You feel me? Like, I know when to fight and when not to fight. If I'm around people I see they gonna really try to hurt me, I'm just letting them jump on me. Cause I'm gonna win in the end. But if I'm around somebody where I just try to fight me, I'm gonna beat him up. I'm gonna fight back as best as I can. But when they put me in there, you know, I was all right. People came like him, man, hey, bro, we salute you, bro. Cause if it was somebody else, they got on their stand and did this and did that. Well, I lied. So I ain't finna go lie on nobody, not mean to justify my lie. So I call my people like, hey, look, y'all put money on the phone and money on my book. They listen to my call. I know they listen. They see that I'm getting comfortable. They removed me from that jail and put me in DeKalb County jail and put me in the whole dorm by myself with no water, no TV, no phone, no nothing. No books to read, no nothing. So I'm like, dang. You feel me? So as in, the next day, hey, can I get a pen number to use the phone? Oh, the system down. But y'all still booking people in. Everybody using the phone but me. Can y'all cut the TV on or the TV don't work? It feces in the toilet. So I gotta walk around like this the whole 24 hours. Can I get something to clean this up? I gotta clean the whole dorm just to get the smell out. The toilet ain't working. It's full of waste. The officer come feel bad for me. Fill it up with bleach. I bleached this thing down so bad that bleach was stuck in my nose. 5 hours later, back stink again. Flies, can't eat the food. I didn't eat Friday, Saturday, Sunday. Monday morning, they came for me. They were looking for me, they couldn't find me. So when they finally found me, I had came out the room. They like, where you been? We've been looking for you. I said, I've been in the only place y'all put me in here. I'm weak. I haven't ate. I haven't drank anything, no nothing. They're like, well, you got court. What I'm going to court for? I didn't know I had to go back to court. So they took me back to the court. And that's when they did all that bullshit stuff that I can't talk about right now. And then I'm explaining to the judge, the DA, I'm weak. I haven't eaten since Friday. I haven't drank anything. This jail is torturing me. I haven't talked to my family, no nothing. They're like, okay. So one of the officers, he felt bad. He gave me like some food. But it was like, you know, the food that they feed the deputies. And he gave me a lot of apple juices so I could get my energy back. But I couldn't eat the food. I just drank the apple juice. So he stopped drinking. He kept giving me apple juice. This the only person that had sympathy for me was the officer. So and I'm telling this to the judge, man, I'm weak. I need to go to the hospital, man. That man's going 3 days without eating anything or drinking anything. I can't even stand up, and y'all gonna force me back in here?
Yeah.
So I want to talk about so much, so bad. You know what I mean? Because I know they're gonna try to shut me up. They're gonna probably try to put fake charges on me soon. You know what I mean? Like, man, I just pray to God that he keep them away from me, though. That's all I ask for.
All right. Well, that part we definitely dealt with. If he was not given, or you have reason to believe he was not given food or drink between Friday and Monday, that's something that certainly should have been raised in the coercion motions that several of you filed, because that might have impacted between the 10th and the 12th. But again, you all decided you wanted the testimony between the 10th and the 12th. And that was a strategic decision on your part because you believed that there were beneficial things that he said during that testimony. I think that advice that these defendants, through their attorneys, would vigorously cross-examine Mr. Copeland is correct and accurate advice, and that these defendants know him better than the state's attorneys know him, or anybody else, is not inaccurate as well. If you would like to, understanding the parameters of my ruling, provide some questions that you believe should appropriately be asked, I'm happy to consider those. And it may be that there are, I mean, you can absolutely, again, ask him about the immunity grant and the, you know, even right now, whether he is only doing this because it's avoiding jail for him. That's fine. You could explore that completely. All right.
You know, you say it to Mr. Schardt all the time, and I always tell him, don't say okay, because it seems like you're
Well,
waving it. So no, it's not.
By which I mean, all right, do you understand?
I
Not
understand.
all right, do you accept my ruling? Because I know you will abide by it, but you
Yes.
do not agree with the correctness of it.
Yes. And then the last thing I'd like to say, if I may.
Yeah.
When this honorable court said I didn't take up the opportunity to strike the entire testimony from the June 10th to the 12th, that's the law. The law is until that motion is filed of recusal. So I'm following the law, and there were beneficial points. I mean, you just read the transcript where he testified under pressure or not, but that is in the case. So I believe that I have a right to ask him about, those days before you took over, before you gave him the proper admonitions and the correct law. So that's
Okay.
all.
Thank you. So that the record is clear, I am suggesting that obviously the law with regard to the timing once a recusal motion has been granted, what you have to undo. Yes. What I'm saying is if you believed that there was coercion starting at some point earlier than that, based on a lack of food and drink or any kind of treatment like that, then that could have been brought up, and y'all chose not to bring that up or not to make that argument. And you all could have agreed to redo the entirety of the testimony, or you could have asked to redo the entirety of the testimony on the basis of it having been coerced, and I would have considered that.
Well, at the time, I was following the court's order, which I didn't think I even needed an order, but that I could cross-examine Mr. Copeland on everything that happened on the ex parte meeting. And that's when I made my ruling, or not ruling, sorry. That's when I said, I don't want it out. In addition to that, I didn't want it out because I want to cross-examine him on why he did it. It's part why he testified from the 10th to the 12th. That's part of the case. And I think that it goes to the jurors. The jurors are entitled to know who the prosecutors are and who the judge was. And it goes to their bias their interest in the case and their motivation on how they are prosecuting this case. So,
Okay, I don't think that any order that I issued led you to believe that you would be able to, well, it may have led you to believe, but I don't think it should have reasonably led you to believe that you would be able to explore anything about what Judge Glanville said or did during that ex parte.
I think that it was clear to me, whether you said it or not, the way I understand the rules, that that's a part of this case, that's a part of this witness, and that it comes out on cross or direct examination. The prosecutors can sit here and say now, maybe they're going to do it. I have no reason to believe that they are or not. But Mr. Copeland, we had a misunderstanding on June 10th, and we had a meeting with the judge, and your lawyer was there the whole time. They could do all that as well. But I don't see handcuffing Mr. Williams' lawyer on cross-examination when it is a reality case. Just like if Mr. Copeland went out and spoke on a jail call and made statements about things. That's his state of mind at the time. It may be relevant. I think it's relevant here. I think it's relevant that Judge Glanville did this and Miss Hilton did this.
You can ask about anything Miss Hilton did.
No, I understand you did not limit that, but you're limiting the way I heard you today. I have to almost excise Judge Glanville, and that's what I'm objecting.
All right. Yes, sir.
Just so I'm clear with what the court just ruled, we can ask about things that Ms. Hilton said to Mr. Copeland during that ex parte meeting. We just can't label an ex parte. This is what I'm concerned with. There's a lot of confusion and I think misunderstanding of this immunity. I understand the order that was granting him use and derivative use immunity. However, Ms. Hilton articulated to Mr. Copeland in chambers much more than that. For instance, my understanding of law, and Your Honor, I know that you've dealt with these issues more than me. The statute of limitations is not what we normally think it to be. It's not from the date of the offense. It's told if there's no evidence of who committed the offense.
Mhm.
That's one, the perpetrator has to be known. So Ms. Hilton said, for instance, we'll use the barbershop shooting. Ms. Hilton said, oh, all this stuff is older than 4 years, so you can never be prosecuted. That he could be prosecuted for the
that's
barbershop
true.
shooting.
But here's the thing.
They would just have to put a tolling provision.
That's not relevant either, because it is not the fact that the statute of limitations may or may not have run that prevents the state from prosecuting him for something he wants to get on the stand and confess to. It is the grant of immunity that prevents that. So regardless of the correctness or incorrectness of statute of limitations comments, they cannot use anything he gets on the stand and confesses to because they granted him immunity, or the court has granted him immunity.
But in my mind, here's the difference. The state has made a deal with the, quote unquote, I'm not calling the man the devil, but that's the say. And there's a difference between them saying, oh, we're giving you use and derivative use immunity versus them saying, we will absolutely not prosecute you. They have basically, I don't know if they checked with Rich Homie Kwan's father, but they've basically given this man carte blanche to never be prosecuted for anything he says. And if I was representing Kenneth Copeland later on and they indicted him for something like this, I would say, y'all must be crazy. Y'all got in the back room and told this man, you guys are never prosecuting him. So they've done more than giving him use immunity. They've given him blanket immunity for everything. And that, to me, is fertile ground for impeachment and cross-examination. And I think the jury needs to know they want Jeffrey Williams, they want Shannon Stillwell, they want these people so bad that they gave Mr. Copeland just full reign to run around Atlanta, do all these things. And as long as you get up on the stand, we're never going to prosecute you. And I think that's relevant.
Okay, well, they didn't give him full reign to go do things he hasn't done yet. So, I mean, let's not get too far afield with this.
Well,
You may explore any kind of interest he might have in testifying in a way that might be beneficial to the state, although I don't think that's happened anyway. Because you could explore bias. You're entitled to do that. But we're not getting, this is not a trial about how the state handled Mr. Copeland or how Judge Glanville handled Mr. Copeland. This is a trial about whether these defendants, whether the state can prove that these defendants committed the acts that they allege them to have committed. And if you want, again, you also, all of you all are welcome if you want to give me a list of questions that or that you believe should be able to be asked. I can look at them.
very well, Your Honor.
All right.
Oh, go ahead, Mr. Chair.
I just want to raise something
Sure.
while you hopefully reconsider. And this was mostly, the prosecutors. I think Mr. Atkins, I was going to exclude him, but I think he did it too. They asked witnesses, to my knowledge, without any basis, well, you're testifying this way, but have you ever had to testify before in front of Mr. Williams? When you were giving your statements, was Mr. Williams present? And then they did it with everybody. Was Mr. Huey present?
Right.
I've objected every time. And it's totally, that's a crime of witness intimidation without any evidence. It's just, and they say, no, I haven't testified at all, but I don't remember, or I told you something wrong, or I didn't say that to you. I want to do now and show what the state is doing to witnesses. And I'm telling you, Your Honor, when Mr. Zachary comes, and I brought this up earlier in a pretrial meeting, my understanding is that Ms. Love had him served, he being Mr. Zachary, served with a subpoena.
Okay.
It's a trial subpoena from what I was told. Ricky Richardson was his lawyer at that time. Ms. Love ordered Mr. Zachary the day before to drive from Augusta, Georgia, miss his job, to her office because she said, if he doesn't come, Judge Glanville will lock him up. There was no trial going on. This in 2023, we were doing jury selection. I heard about that, so I raised it to Judge Glanville. This is abuse of power. You don't order somebody to come to your office with the hammer of the judge going to lock you up. Judge Glanville said, put on your evidence. He gave me an opportunity. Everybody said they didn't want to testify, so I didn't call anybody. Ricky Richards, I didn't call anybody, so I forfeited the motion. But my point is to say that, somehow there's witness intimidation from Mr. Williams et al. I want to show what's really going on, and that ex parte meeting helps illustrate it. I will also ask Mr. Zachary, because I'm confident he'll know. It was not attorney-client privilege because it didn't just come from Mr. Richardson. He told me, you can also speak with Mr. Zachary with Mr. Richardson, and he'll tell you the same. That's all we spoke about, coming to court. And he did come to the courthouse. I'm told that his father met him there too. This could be wrong because I'm not there. And then his father said, the law, there's no trial going on. My son's leaving. So there was no conversation.
Okay.
But my point is, this is not an isolated incident, and I'd like you to just allow the truth to flow. I'm not going to hurt Judge Glanville. I'm just going to state what was said. That's it. And it's really the impact, like you said, on Mr. Copeland.
All right. Thank you. Sure. Do you want to wait and see what Mr. Weinstein has to say first?
Okay. Briefly, Your Honor. The discussion this morning came up about Mr. Copeland being deprived of food and water at Rice Street, as well as conditions, other issues that happened at Rice Street between June 7th and June 10th. And I believe the court said, I may have misunderstood you, that several attorneys filed motions regarding the coercion in the chambers. Perhaps this is something that we should have brought up. I was completely unaware that happened.
Well, it's not, I'm sorry to interrupt, but I'm not sure it did happen. He has some reason he thinks it may have happened.
Okay.
He Mr. Steele, but okay.
So I did not learn of this possibly happening then, let's put it that way, until I saw Mr. Copeland on social media this week So this isn't something that I could have brought up regarding Judge Glanville and the coercion that took place. So if we do get further facts of that, I would like to bring that up with the court again, because it sounds like that could have influenced your decision on the coercion. Perhaps not, but I would like to bring it up in the future.
All right, thank you. Mr. Engelberger.
Yes, Judge. I'm a little late to the party, obviously. When we're talking about privileged communications, I understand there may have been a hearing about what was said to or discussed between him and his other lawyer, but as it relates to any communications between my client and I as of August 12th of, August 13th of 2024, obviously I would assume this court understands those would be off the table in cross-examination.
All right, as far as I know, there haven't been any hearings about anything that was communicated just between Mr. Copeland and either Ms. Bumpus or Mr. Melnick. There was a hearing about things that might have been said with Ms. Hilton present with Mr. Copeland and Ms. Bumpus.
Okay.
Yeah, certainly. I understand privilege. Thank you.
What are your thoughts? Leave us a comment. Don't forget to hit the like button and subscribe to the channel for more content like this.